Good afternoon. So we are going to speak about climate. We have a very distinguished panel today, and most of my panelists understand disputes from all perspectives. We will make a connect with environment and the climate and the sustainability and the challenges which are being faced by the planet. With me, my co-moderator, Purnima. She is going to basically ask questions with regard to all the international movements which are happening. We have Manini, who will talk about ICC related and other aspects, whichever country and jurisdiction she sees, whatever movement is happening on dispute resolution and climate. Daniel, he will talk about whatever is happening in UK jurisdiction. And we will have Alishan, who will talk about variety of issues with regard to other mechanisms and climate change disputes in general. Kunal will go into detail about few European countries, which he has already talked about. He has been part of the ICC discussions on climate change. And while everybody is coming in, I'm just generally going to give you a flavor that we will have time for question answer at the end. I'll speak few words, then Purnima will initiate the subject. But there is a very historical date, 11th August 2021. During the height of pandemic, 4,000 lawyers virtually assembled for American Bar Association, and John Kerry, USNY for climate change, addressed them and says, from today, all of you are climate change lawyers. And why did he say that? That's something, it's a reverse progression we'll do. So across the world, this is the debate. What is happening now? From Paris, I would say from 1971 till now, bit by bit, commercial considerations and sustainability, they both are coming together. They both are becoming the same thing. You cannot disengage each from other. Your contracts, which have to now take care of all kind of developments, energy transition, supply chain movement, environment, social governance issue. If you are asking for money, if a company which is into green funds, which is into developmental funds, which is into any kind of financing, across the world there is a new churn happening that if you are linked with any way with the climate, your dispute resolution mechanism also has to have a quote of sustainability. Now that's the movement which has already started happening. One example which is very glaring, which I want to give you, that ICC did its report on climate change disputes in 2019. For the first time, organized movement started that climate change disputes will be something which will not be fought traditionally in different jurisdictions. They will also be done through arbitration mechanism. But that was 2019. In Egypt, in 2022 November, when COP happened, a major transition happened. Whatever was a hypothetical case mentioned in ICC report, verbatim, that was opted by the Egypt declaration. And what was that? That the rich countries will have to compensate the poor countries through agreements, through arbitration mechanism about the compensation which they have to pay. This was a watershed moment. Now, just see what is happening around you. You are a fifth largest economy here. You will do series of agreements for all kind of work, whether it's shared mobility, whether it is e-commerce, whether it's plastic waste disposal, your technology transfers, which will happen to promote sustainability. All of them, the boards are being encouraged to do everything virtually. So you won't go to Davos and you will debate on world economic issue in 400 jets and talk about sustainability. Now the boards are being told in the agreement itself, what will be your dispute mechanism, who will decide about it, and how the dispute has to be taken care of. So these are very fast-paced development which is happening. In the course of our entire discussion, we will go into detail of all these aspects. So I ask Purnima to now give her opening remarks, and then we'll take it to the panelists.
Thank you. Thank you, Sudhir. Thank you for staying on without that coffee break, and hopefully we'll stick to time and being patient with the afternoon sessions. So I think just some opening thoughts on climate change is the nature of the dispute in itself, whether a climate change dispute is amenable to arbitration. In India, all with our rich history of environment jurisprudence, it's always been the courts that have led the way. Almost always there's been a public interest perspective, a human rights perspective, an environment perspective, with so many stakeholders that evolve out of a context of climate change. Right? So if you're talking about the 1.5 degree centigrade increase, if you're talking about the polluter pays principle, if you're talking about, let's look at the Bhopal gas tragedy, would all these contexts or disputes, they're not restricted to a few people, but there are a number of actors. There's the state actors, there could be a tribal group, there could be a corporate. Would they be amenable to arbitration? And if so, what way would we look at it right now in 2024? The other issue that we'll touch about a little bit is we're not going to have an arbitration clause that would encompass all of these. Then are we then going to be entering into agreements to bring everybody within this four? And what about transparency versus confidentiality? At the core of arbitration is confidentiality as its strength, but if you have a public interest perspective, or people are relying on precedents, say, what Sudhir, you mentioned about what's going to happen in Egypt, and if we want to replicate that here or somewhere else, we want to know what's happening. Would it help then that arbitration would be the way forward? So I think these are some of the issues that we'll touch on as we go, and we do hope that we'll have some question answers. I think we'll now start with the panelists.
So, I will start with Manini. Manini, with your experience in arbitration proceedings, and what, according to you, are the most important aspects of arbitration that support the resolution of climate disputes?
Thank you, Sudhir, for that question, and I'm really happy to be here, so thank you to GAR Live. I just want to start by saying that these views are personal and they don't represent the views of the Government of India, who I advise in a slightly overlapping capacity. But let's start with the United Nations Framework Convention on Climate Change, which is really the root of a lot of the subsequent agreements that have followed, whether it's the Kyoto Protocol or the Paris Agreement. And if you look at the dispute resolution clause in the UNFCCC, it actually makes conciliation mandatory, but not arbitration. You have to, the state has to specifically opt into the clause by way of a declaration. So that's interesting that the first port of call is the peaceful settlement of a dispute through conciliation. But that said, the PCA itself, which is an international body, the Permanent Court of Arbitration, of much repute, has done a lot of what would identify as climate change disputes, including the Kishan-Ganga dispute, the Indus Water Treaty dispute, which is a dispute around natural resources. So that dispute and the more recent South China Sea dispute. So clearly they are doing something right, and they now have the PCA optional rules on for this purpose. They're called the PCA environmental rules. So from that point of view, what are the things that facilitate the reference of a climate change dispute to arbitration and how it can work? I'd say the first and most important thing, which Purnabha has already mentioned, is it's not a two-people dispute. It's not claimant versus respondent. It involves broader interests of the society. And arbitration, by virtue of being a flexible process, allows for the arbitration to be as transparent or confidential as the parties require it to be. So, for example, the PCA rules do emphasize on keeping the submissions and the process open unless a state or a party requests otherwise. So transparency is something that arbitration can give you in the right context. Third-party participation, again, in amicus curiae representations, can be built into rules, and that has been done as well. But I think the most important tool really is the speed-bound nature of the process, because every environmental dispute or disputes around natural resources have an inbuilt urgency in them. The more you delay it, the likely impact of the fallout is much bigger. And arbitration has a host of flexibilities in terms of being able to provide urgent and interim relief, in terms of being able to tailor the process. You can have a case management conference, you can bifurcate proceedings, you can have cost allocation decided right up front. So there is a lot that you can do to expedite the dispute, and I think that's particularly relevant in the context of climate disputes.
Daniel, if I may ask you next, does arbitration really lend itself in this context? Some of the things that we've touched, and if so, would clauses work, or would submission agreements work better?
Well, I think it's fair to recognize that arbitration has garnered a somewhat bad reputation among some climate change campaigners, based mainly on the use of arbitration in a bilateral investment treaty context and multilateral investment treaty context, particularly under the Energy Charter Treaty. And so I think, just to give you to see how that is reflected, if you look at the UN climate change report on climate change litigation that came out last year, you see arbitration is put in the bucket of anti-climate litigation, or so-called backlash litigation. And I think the reason that one has it's got that reputation in some quarters is because of those claims that have been brought by fossil fuel companies against states seeking compensation for legislation that seeks to remedy climate change. So, for example, legislation that seeks to stop coal production, or that takes away oil licenses, and it's perceived that though arbitration in that context acts as has a chilling effect on climate change legislation. And so I think that that can be mediated and can be mitigated by a number of measures. One is by changing the terms of the bilateral investment treaties and multilateral investment treaties. But another is, I think, by somewhat different interpretation of the fair and equitable treatment concept in that context. But I think the real future here is actually in submission agreements, which one does see sometimes actually even merged with bilateral investment treaties. So, for example, there's the cases of where Burlington brought a case against Ecuador, and Perenco brought a case also against Ecuador. These were oil companies that made allegations under the relevant investment treaty against Ecuador, and Ecuador counterclaimed, saying, "Well, you oil companies, you violated Ecuador's environmental laws, and in particular, you harmed the rainforest through pollution of the soil." And the parties in that context submitted. They entered into a submission agreement, and to have the counterclaim determined as part of the same arbitral process, and it actually resulted in a very good outcome for Ecuador, with over $30 million dollars in compensation. So I think that there's real future there in submission agreements, in parties consensually resolving their disputes. And this isn't a novel thing for environmental claims. I mean, it goes back to classic arbitrations like the Trail smelter case, even in Canada. Yeah. So I think that is a future, if people can understand that there is really that arbitration does work for these types of dispute.
Yeah, Daniel, that's going to open a Pandora box, actually, when we come to Alishan. Alishan, before you speak, so we are going now into details of agreements. Bilateral investment treaty was one. Wherever we go and try to attract investment, especially countries like India, we are talking of investment in companies in sustainability. Now, how do you see clauses being redrawn now? You have examples of various countries. Clauses will be redrawn, even the way arbitration will be done at a forum where the arbitration will be done, which will have a climate connect.
See, now when we talk about investment treaties, bilateral investment treaties, just to give my perspective of it, what they do essentially is they protect two things. One is that when two countries enter into a bilateral investment treaty, just going in a little bit of detail, and like Daniel indicated, is that you have protection. You offer protection to the corporation of the other state, in the sense that against expropriation of their investment, and also guarantee them equal treatment. Now, they can be of various types. They can be most favored nations. They can be bilateral investment, multilateral investment treaties and all that. Now, if the disputes come in, the reason for that also, when you said climate change, if the dispute is between two states or corporation of one state and the responsibility of the other state to protect the investment, where would it go? Naturally, you have in some treaties the clauses that you will explore, like in Indian one also, they modified, that you have to explore the domestic remedies first before you go for that. But ultimately, when it comes at the state level, either you go to International Court of Justice when there is a state level dispute, country level dispute between two countries, or you have an arbitration mechanism which you enter. So the way forward I see, when you have a lot of agreements, which are climate agreements from Paris till Egypt, you said, and between we had Glasgow and all that, and we have undertaken obligations. What we do under those agreements? We sign an agreement, then again we submit our plan, the national plan, to abide by the commitments, and then we come and make laws. Now, where does the conflict come in? On one hand, I have bilateral investment agreement, wherein I guarantee that I will protect the investment of a corporation in my country. On the other hand, I have obligations under some of these international climate change agreements, under which I have to protect the investment. So suppose I have to eradicate fossil fuel. What do? Greenhouse, they seek to arrest the emission of greenhouse gases. They propose to eliminate use of fossil fuel, right? And also environment-friendly things to be promoted. Now, when you have a corporation from another entity investing in your country, and they are doing, suppose in coal production, then the moment you make a law, there can be a conflict. So what happens in that case? In that case, I'll cite 3 examples. RWE versus Netherlands is a case wherein a German corporation, Netherlands came up with the Coal Ban Act. And the timeline was there, and Daniel referred to Energy Charter. It was related to Energy Charter as also the Paris Agreement. They came up with a law, and they said the time provided to us is not reasonable, and also it is not in line with the domestic corporations. The case was ultimately withdrawn because of defects. Costa Rica, an old case, Santa Elena versus Costa Rica, in which there was 1,500 hectares of land which was purchased and run from 1970s by a US corporation through its subsidiary. Government converted into a national park. And ultimately damages was given on the principle that you may have an obligation under an environment protection law, or you are entitled to protect your environment, but nevertheless that is a breach of a bilateral investment treaty. So while you do an investment, while you protect your environment, you still may have, the state may have a liability towards this. The third case that I cite is again related to oil exploration, which is Rockhopper versus Italy. And in this case, Italy by law banned oil exploration, oil and gas exploration activities up to 12 miles from the coastline. It was challenged, and ultimately they had to pay the compensation. So what happens when this conflict comes in? What Daniel talked about is that we have to have bilateral investment agreements which give a way out and which read down these clauses when it comes to climate change. Otherwise, you will run into liabilities. The states would run into liabilities.
Thank you. Thank you, Alishan. Kunal, if I may, you've been part of the task force and the ICC report on the topic that we're discussing today. And it's a 2019 report. So the question really is, are we moving ahead? Are we actually adopting these clauses, the idea that climate change can be arbitrable? Is there a willingness that you've seen amongst industry or among state actors? What are your thoughts?
Thanks, Purnima. In fact, I pardon my voice, I am also subjected to some climate change in my voice. But to answer your question, Purnima, in fact, at the ICC court, what we have seen is about 70% of the disputes accounted for climate change. And that, I think, was the percentage that we saw in 2018, which led to the task force then getting into preparation of the report. The report does bring out a whole mechanism which is mirrored with the PCA. The PCA environmental rules have been in existence for a very long time. I think immediately or just immediately after the Paris Agreement, they were in place. And PCA does have a panel of 25 expert environmentalists who are arbitrators and about 17 to 18 scientific experts who deal with these kind of disputes. So there is a move, there is a willingness, there is about 40% which has moved about in terms of resolution, in terms of statistics, that 40% of them in various regions, I've noted down the regions. It's the Kingdom of Saudi Arabia, the coastal and the marine development in the entire UAE region, the construction of seawalls and the other longitudinal shoreline areas. I think these are spaces where the disputes are emanating largely, and we are seeing large amount of disputes. But where the deadlock is the non-willingness of public participation in these kind of disputes. So the parties have to consent to public participation. Otherwise, what I have seen and what studies show is multiplicity of proceedings in the same arena.
Sorry, I'm just going to ask a follow-up question there. Then how do you get that public participation? I mean, where is the awareness, right? I mean, not in sort of the hallowed rooms such as these, but everybody knows where the nearest court is, right? How then does the farmer know where to go, or a group of tribals, or whoever else is affected? How are you going to get that involvement?
So I think awareness is in terms of the nations which will have to build about these consensus. It is the nations who are signing these conventions, who are parties to the bilateral treaties, and they obviously have to trickle it down within the ecosystem of their own nations to create this kind of awareness being allowed to the general public which is in the affected zone, or the nation takes the initiative to sort of build up that kind of organizations which can then take causes forward. We've seen India work on various of those organizations, various of those movements. But the problem is the parties don't allow that. And the tribunal is then not able to allow third-party intervention in those disputes. And although the rules of the institutions permit them, the rules of all the institutions, if you take the ICC rules, if you take the PCA rules, or the ICSID rules, all of them permit third-party intervention in these kind of disputes, at least by way of oral submissions and written submissions. So the deadlock, when you ask me a question of where is it going forward, there is a deadlock because then you are not seeing the real resolution and there is multiplicity of proceedings everywhere.
Okay.
Thank you.
Okay. So the first round, we have almost tried to sketch a map. What has come out, Daniel made an important observation about the submission agreement. Now, whatever my panelists are saying, what Purnima has said, there are deadlocks, we have confusions, but the road ahead, it's not a choice, it's a compulsion. So what compulsion we are looking at in supply chain contracts, in ESG-driven supply chain issues, where one country is providing something for another country, where two companies based in two different geographical jurisdictions have issues, and there is a environmental wrong which has happened, the incidence of environmental wrong which has happened, the local community goes to the court, but the court is not going to provide a remedy because there is an arbitration clause. So what happens, even in domestic disputes as well as investment-driven disputes, submission agreement is the increasing reality which is going to happen. And the courts are going to promote it. Even if you have arbitration clause which is not mentioned about it, if an affected community of laborers, tribal people, fishermen, school children are affected by them, it is happening. In Bangladesh, it has happened in a supply chain contract where arbitration, the local community has been allowed by both the parties to come and make their case out of it. So this is the new reality you're looking at. So I would say, Manini, what do you think? Have institutions able to catch up? Do you think institutions have responded adequately to climate disputes, especially ICC?
I mean, so I think it's been said several times on the panel that one has to understand the reality of a corporate and the environment in which it functions. It's like, just like a human being has a carbon footprint, the corporate will inevitably conduct itself in a manner where resources are being consumed and something is being wasted. And I think if you start from that place, then arbitration, in order to be relevant, has to adapt. And I think the ICC task force, which Kunal has already mentioned, recognized that. And so do the PCA rules. So we had tipped to the PCA rules because they specifically talk about third-party intervention, and the criteria there, if I remember correctly, is a genuine interest in the dispute. And more recently, in the context of the IBA work on this, the IBA model statute to challenge governments for failure to act, that statute actually does not, it's envisaging a dispute in a court context more than, you know, in the context of an arbitration, but it specifically says that third-party intervention will be evaluated based on your standing and based on the genuineness of the interest that you have. So I think we need to take a leaf from that.
Okay. So I have a follow-up question for you. You know institutions and you understand institutions. So if an investor is there, or even there are two companies involved, they will prefer to engage with a specialized climate change dispute arbitration center. What do you think, where are we going to head? Because ICC is a reference point for even now COP. Yes. They adopted whatever ICC said in 2019. Yeah. So which are the institutions which are getting ready to provide a platform for climate change disputes through arbitration?
So that's interesting because the ICC also has an ICC ADR center, which provides facilities to administer the entirety of a climate change dispute. So they will help you identify a particular expert, whether it's a tribunal expert or an expert in order to give evidence. If the parties approach it, they will be able to guide you through the process, and they will be able to supervise. So you have center-based institutional assistance.
So after this conference, we will have such a center now, which can be in Asia, India. Is there a possibility?
I will not comment on.
Okay.
I will not comment on the Indian on the Indian position on this. What I can say is that all countries are on board and they recognize the absolute imperative of sustainability, and so everybody's on board with that. But the ICC has that, the PCA has that. Kunal has just mentioned they have a list of experts, it's a very clear, very transparent process. They even envisage the appointment of 5 arbitrators. So each of the parties can appoint 2, and then the 2 that are selected appoint 3 more. So you can have a level of technical expertise at the top, even if the parties have not selected it. So I think the institutions are alive to these possibilities, and everybody's trying to put all hands on deck. Let's see how it goes.
Thank you, Manini. Daniel, coming back to your submission, and now there's been a whole further round of discussions, and I'm going to play the devil's advocate and say courts are still the better, easier way to go until we build capacity, until we build the institutions that that we want and talk about. Well, if somebody comes to the institutions, great. But have you seen any examples where you could draw on to say, no, arbitration really is the way to go, and this has worked in these contexts?
Well, I think the Burlington and Perenco against Ecuador cases that I mentioned is an example of it working. You also had the Allard case where Mr. Allard sued Barbados in relation to his eco-resort in Barbados called the Sanctuary, which he said was being polluted by the actions of the Barbadian government. Of course, the claim didn't succeed, but there are those examples. But I think I would take issue with necessarily the best place for these disputes. I think a lot of claimants think that because they've seen some victories in the courts, in the Netherlands in particular, of course, famously. But one does also have to bear in mind the natural advantages of arbitration that Manini has already mentioned, the speed factor. I mean, just not having to go through multiple levels of appeal is very important to claimants if you want speed. And also, of course, enforceability, because arbitral awards under the New York Convention are so much more portable than most court judgments. And so I think there needs to be a bit of a rethink on the claimant side about arbitration. I think that it's actually, particularly with these institutional developments, which allow for amicus curiae from third parties and for third-party interventions generally, I think it's actually a very promising forum also for claimants, for people trying to promote climate change action to bring their disputes. And I think it's more of a perception issue than anything else. And I think claims will come in due course. At least I'm hopeful they will.
Thank you.
Okay. Thank you, Daniel. Alishan, before I come to the question, because the question is, you have been talking about air pollution and other stuff. That's a question we discussed outside. Let me tell you, in this building only, we have one of the biggest air pollution petition going on in Delhi High Court. They have taken giant steps to do that. What do you think? That are there other forms, there are other places where you can do dispute resolution on environmental issues? Or do you really feel that environmental disputes, what Daniel also said, the court is a better place or some other place?
Well, I would believe that it will be a combination of this. When it comes to the dispute between the corporation or underwriting the investment of a corporation because of a change in climate policy or a law, of course it has to be through arbitration and through treaties. When it comes to individual rights, I do believe, I have my reservation how intervention applications will work in arbitrations which are confidential by nature. Now I cite some examples, the real life examples. I live in Gurgaon, and if you Google Cancer Village of India, you will know that there is a garbage dump not very far from my home, and in that village, because of the pollution that has caused in the last 10 years, every 3 households has 1 cancer patient, and it's well reported. It's called Cancer Village of Gurgaon. Delhi, we know, every year we have restrictions because of air pollution. Now these issues, today I feel.
I'll just tell you a clue. The Delhi High Court petition is in my name. Sudhir Mishra was a Union of India.
I was about to
go. No, that is not important. The important part is it is not filed against Ministry of Environment and Forest. I have filed it 10 years back against Ministry of Health and Family Welfare because I said I don't want cancer. They said, no, go to National Green Tribunal, go to Supreme Court. There were various petitions already pending. I said, no, I don't want cancer. So I have come here. Right. And so they issued a notice, and that's being heard for 10 years. Now, what do you want to take up for the cancer capital thing in Haryana? What do you think can be done about it?
See, what can be done? All I know is that 300 crore rupees have been spent and 400 crore more are to be spent. 33 acres of land is occupied and the mound is visible, I think, from aircrafts. Right? So, and the judges and the courts are doing their duty. The problem is in execution. The orders are there. You yourself said 10 years. Yes, but what has happened in these 10 years, the mound has only grown higher. It's 33 meters, last I checked on Google, 33 meters high. We are prohibited from driving vehicles of certain specification of certain numbers in NCR where we are sitting during few months every year. And the concept is polluter pays. My small car, which is BS3, is stopped. I am paying for it by not driving it, but at the same time trucks ply in Delhi or through the night, and I hear debates for years altogether that we have peripheral roads. Where are they? Why do trucks drive? So what I want to say is judiciary is doing its job, thankfully, to all our honorable judges. They are doing. I think it needs to be far more strict, because what we are saying is administrative failure in execution of their decisions.
Thank you. I think that debate has gotten a little more heated and more contextualized. And, those of us who are not from Delhi, we're always wondering how you live in a city, on those
Bangalore is catching up fast, don't worry about
very quickly, but not yet there.
You wanted to do a tunnel connecting the airport through the city, and I was handling the Lake City matter in Supreme Court.
Still see
so Bangalore just is lucky. We are not that lucky because of our geographical features.
But going back
Delhi.
to Kunal, so Kunal, just what would you write into these clauses, right? If we were to choose to arbitrate all of these matters, and you heard the kind of complexity, Bangalore, Delhi, doesn't matter where it is. And in your report, the ICC report talks about industry-specific clauses, right? Like FIDIC. Can the solar industry have a clause? Can the petroleum industry, oil and gas industry have a clause? Wherever there is energy, would there be different clauses? And what would go into those clauses? And if you could contextualize it a little bit for India and the problems that we're seeing around this.
So the clause is, in any event, going to be generic, because you have the choice of choosing your governing law, and the manner in which you will deal with such kind of clauses would have to be very generic in nature, because it will take into realm all sorts of climatic disputes within it. So putting it to industry specific is not really the key. What you mentioned as examples are where you are going to refer to these rules or to those experts, because you emanate out of those industries. So when you talk of FIDIC, it's the construction industry, and that's why you choose FIDIC. And that is where you can take it to the experts. But coming back to the international arbitration that we were discussing, what is important, and what Daniel said, is that can arbitration regime offer anything more or better than courts? Or is there something that we are seeing better in the international arbitration regime? And my answer to that is in the affirmative, to say that it is a definitive mechanism in terms of timelines by which, at least from the Indian perspective, you will reach a destination of an award. Second, if you take the institutional route, and I adopt the same caveat as Manini, that I'm not talking for the ICC, but ICC is in the forefront in the realm, so don't mistake me as the court member promoting ICC. But for ICC or PCA, whatever you may see, the rules are robust enough to take care of each of those situations where you will have enough of transparency available in terms of these disputes, because it allows public participation, it allows you to redact the awards, so all the portions of the awards will come out to be redacted, and in case of ICC, we publish it only at the end of 2 years. So the confidentiality, which is one of the issues Daniel raised, would also sort of stand protected to that extent. And therefore, it is not just courts. I think the willingness and the perception has to move towards the international arbitration, and that is probably the right mode. And that was the focus of the task report in 2019, that there is a robust alternative mechanism for resolving climatic disputes available. And it's not far gone. It's right there in front of you. One other aspect in this entire realm, which we can see and which was also raised, is that today the rules are robust enough to have emergency arbitrators. So you are going to get emergent orders, emergent awards available in terms of grave situations coming by. So it is not that you need to rush to court. The alternative mechanism in the international domain is fully robust enough to solve every kind of logistical issue that you need for an effective resolution.
Thank you. I think we'll do one more round of quick comments and questions, and if you could keep it brief, and then we'll open it up to the audience. And I'd like you to think a little bit about enforceability, depending on, from the point of context you're coming, whether it's emergency arbitration or otherwise. Sudhir, you want to start?
So basically, one aspect which we need to touch in detail is the contract writing now. And we understand disputes, we understand arbitration here. But what about chartered accountants? What about fund managers? What about capital owners? What about bankers? Are we interacting with them to tell them how they change their contract writing? Who is writing their arbitration clauses? So this is something which is very important, because after Paris, your contract writing has to go on with what Purnima said initially about the 2-degree temperature. That's your cornerstone. That if you are any kind of transactional lawyer, even you need to know what will happen tomorrow. So what is your way of contract writing? For example, I'm just reading exactly from ICC. Contract can be executed between investor, state, and industry body in conformity with Paris goals. So that was the expectation, which is now slowly percolating downwards into domestic writing otherwise. One major thing which Europe has done, and especially UK, where I spend a lot of time in my chambers, that they have a Chancery Lane project. And the Chancery Lane project is a voluntary project. So how do you write those contracts which somehow promote sustainability? So even a real estate development or a supply chain agreement or a fashion sustainability brand, if they're doing a contract, they will write conscious word which promotes sustainability. So these are the things which have to be localized in different jurisdictions. Even how will you find so many environmental experts? Like as an expert witness, we all have been going for 15, 20 years for arbitrations where there is a oil and gas leak or something like that. I have 2 or 3 such occurrences. I think the entire arbitration gets benefited with that perspective. Do you have a pool of social experts in this country or in any country who understand that what are the social forces which are part of the ESG parameters? So these are the new domains you will have to have. You will need environmental judges who have presided over environmental courts as future arbitrators, or environmental lawyers or new age environmental lawyers who will preside or who will be part of these arbitration proceedings. So contract writing and having a pool, resource pool for dealing with the new kind of situation where everything is connected with climate goals, you need an entirely new generation to work with. Purnima.
Sudhir. Okay. No, I completely agree. What I was just trying to understand, how do you grapple with enforcement, right? I mean, if, Alisha, you're taking your example of the growing mound in Gurgaon, and if you did get some emergency relief or for the air pollution in Delhi or whatever else, would we be able to enforce those better than court orders? I mean, that's really through arbitration. And so you talked about your case being here for 10 years. And going back to Daniel's point, would we have achieved more through international arbitration or arbitration through an institution set up? So I think if we could just address some of these issues in the next 10 to 15 minutes, and then we'll open it up accordingly.
So, Manini, your turn again. Solutions and also concrete steps for creating what Purnima has said, that emergency issues, how we'll deal with. You are already, arbitration itself has challenges. What are these new things we will propose for putting climate also somewhere there?
So I just have a couple of things to say. I know that there's a wealth of experience to my left, so perhaps they can find better solutions. But I just have a couple of things to say. One is that I think when we talk about climate disputes, we're really talking about any dispute that has climate-based ramifications. And that in itself is a very broad canvas. So when you talk about enforceability, what you're really looking at is how enforceable are arbitral awards in a particular jurisdiction versus how enforceable are court orders. And my sense of issues around environment and such concerns is that these are essentially international obligations because they involve the community of nations, right? So it's everybody's collective responsibility to take that home and to secure enforcement. And the moment you have an international tribunal saying, well, India is, or another country, the UK is not compliant with this and needs to take action to do this or to pay compensation, I think for any law, international law abiding country, that is sufficient. I really don't think that you will have a country which will not abide, you know.
So I just had two additional thoughts. One is that I very much agree with Sudhir that it's crucial for these types of environmental climate change claims to have the expertise. And you need you need scientific expertise in numerous different disciplines in order to resolve many of them. And I also think that you're likely to build up that body of expertise much more swiftly in an arbitral setting than you are in a court setting. And so I think it does lend itself. Another reason, I think, why these disputes do potentially lend themselves to being arbitrable. But I think one point I think we haven't really discussed directly is this question of publicity. Because I think for many claimants, that what attracts them about court rather than arbitration is that it's very much in the public gaze. And a lot of what they're trying to do as claimants is to get attention, to get publicity. I think that as one moves from sort of publicity and, dare I say it, a bit of virtue signaling to actually trying to get things done and practical efficacy and enforceability, I think we'll start to see a shift towards arbitration where you get the awards quickly and they're enforceable.
Wonderful. Alishan, before you say something, because you have really taken it wider, in last 72 hours, something very magical has happened. Our Supreme Court has said that tiger is for the forest, forest is for the tiger. So they are fighting that battle. The courts are fighting that battle. What are your suggestions with regard to understanding of this entire thing? There's one more factor which we need to think here. We cannot no longer play the same role that everybody has polluted. Now it's our turn to pollute. So let's not think about sustainability, all this. I'm talking from Indian perspective here. You are a fifth largest economy. You have new liabilities, new responsibilities to the world. So all of this you will have to do. You have to conform to each and every ESG norm, supply norms, and you have to compete there like a developed nation. How will we prepare ourselves?
See, first of all, the whole idea of the key principle is already there. Polluter pays. The fact is that when we are talking about emergency procedure, what we need here is emergency enforcement as well. What we are seeing is lacking is enforcement. The laws are there, like you yourself said, the court orders are there, NGT is there, passing fantastic orders. Forest is tiger, tiger is forest. In fact, in the area of forest is where I see they have made core zones, buffer zones and all that, they have implemented somewhere. But then day-to-day issues, we have a problem. So enforcement shall be merciless. And there are two types, two sides of the coin. One is where the state compensates a corporation for a law, that is what we have covered. But how does the corporation compensate the state or the individuals for the pollution and the problems that they have done? More importantly, where the bureaucrats have failed to perform pursuant to court directions. That is where the merciless issue needs to come in. Second is just a short thought on damages. We talked earlier that damages may be invited even in cases unless the bilateral investment treaties are qualified to protect climate change. India has done with the Kyrgyzstan anything which is related to protecting the environment will not lead to damages under that treaty. Netherlands has done, as Daniel mentioned. Another aspect is that while you calculate damages, assuming in the previous round of treaties where the carve-out was not there, how you calculate damages? The arbitrators have struggled in many cases as to what should be the principle of calculation of damages. My suggestion would be that there should be a negative adjustment also. If somebody is polluting and that person is stopped from that activity, he does not entitle expropriation of damages just because it is in the BIT. Like you mitigation of damages is a concept under Indian law. If you are doing some wrong to the general public, there should be a negative adjustment. Those are my parting thoughts. Thank you.
Kunal, quickly, if you could, where is this merciless enforcement going to come and how is it going to happen if people are not listening to the NGT or the Supreme Court as it may?
So I'll go back to the international perspective and straight to the topic on the international arbitration regime, because that's what I would want to promote. And that's what I am convinced to be the most robust way to do it. And And our savior is in place since 1958, the New York Convention. The New York Convention will help you enforce and get you the award enforced across worldwide. So the international regime or the international arbitration route to resolve climatic disputes is the most robust way to do it, because you have the New York Convention protecting you from over the last several years, and 1958 Convention has not been disturbed with and has been the real role model on how enforcement has effectively worked globally. So I think the worry of enforcement is the last thing, because that's not the concern. The concern is what Daniel raised, the willingness to go there, the parties willing to submit their entire claim to international arbitration is the move which we need to advocate.
Thank you. We have just about time for a few questions. I see two there. We'll take two together, and if you could please be brief, so then we'll see if there's anybody else in the audience.
Hi, I'm Rupali from Trust Legal. So my question is, do you think there is any limitation to arbitration proceeding with respect to the way new principles are being developed while we are handling court proceedings? So a judge has the ability and also the power to come up with new principle. Like we had the discussion about absolute liability and strict liability. Like the principle of strict liability was prevalent, whereas the principle of absolute liability was devised by the Indian Supreme Court. So do you think that such kind of limitation is there in arbitration proceeding, that they cannot come up with new principles in that way? And to add on to that, so for example, we're talking about international arbitrations. In India, we adhere to the principle of absolute liability, but say we go to a jurisdiction where the principle of strict liability is applicable. And in an international arbitration, they decide, say, to adhere to the principle of absolute liability. What will be the enforceability of such an award in that jurisdiction?
Essentially, if you're talking about a private dispute which is based on a contract, the contract is usually rooted in an applicable law. And if the if the applicable law evolves, then the arbitration will take that into account. So if it's happening in the Delhi High Court and the applicable law is the law of India, then the arbitral tribunal will take that into account. With respect to investor-state arbitrations, that becomes a slightly more complicated question, because there are usually the treaty governs the settlement of that dispute, and so how the treaty is to be interpreted is what is relevant. So if it's a recent treaty which is taking into account, like somebody mentioned before, issues of sustainability, then it will be interpreted as such. So I actually don't think that's much of a concern. The only aspect in which it will be concerning is when you look at international law under Article 38 of the ICG statute, because those are limited resources, and some of those are require the consensus of states and a developed practice over a period of time. So that's slightly difficult to crack. But in all other departments, I don't see how arbitration is different. Somebody else has something to say.
One more, and then we'll take. Is there any other hands? We'll take one from that side. If the mic could travel quickly from here to here, and then we'll answer it in one go. Thank you.
Good evening. My name is Mishra, and I'm practicing in Mumbai at the moment. My question is pertaining to what Daniel had raised earlier with respect to a chilling effect in terms of regulating foreign investor behavior. So how does a host state that is in requirement of foreign investment balance its needs of public policy protection, environmental protection, as opposed to becoming an attractive state for foreign investment? And how does international arbitration play a role in that? Do you start drafting the FTAs or the BITs in such a way that involves, that takes into account the chilling effect, or how do you manage that?
Well, I think the short answer is that there is a new generation of bilateral investment treaties that are now incorporating into their drafting the express right of states to regulate, and in particular to regulate for environmental and climate change matters. But I also think that there is an argument to say that there needs to be a further development, which is really to to change the approach that's developed to the fair and equitable doctrine, under which a radical change in policy or of the regulatory framework is regarded as something that is unfair to the investor. Because, I mean, climate change requires radical measures by its nature and in order to mitigate. And there's, I mean, I actually wrote it out. There's a very powerful dissent by Zachary Douglas in a case, Crook and Spain. And I'll read you what he said. He said, in an era where radical reforms in the energy sector are not only desirable but necessary for the sustainability of human life on Earth, it seems incongruous now to be interpreting the FET standard as requiring states to buy back their rights to implement reforms at the highest price. And I think that has got some real force in it. And I think there may well have been some arbitral overreach in saying that any radical change like that is unfair or inequitable. It seems to me it's probably not.
Thank you.
Last question. I think there was just somebody from that side. We should pass the mic. Yeah, go.
Hi, I'm Arijit, and since we discussed newer generation of treaties, I had a question regarding carve-outs. Even if certain newer generation treaties, such as I believe one proposed by the Netherlands, it does provide for stricter carve-outs. We have seen from instances like Eco versus Colombia that carve-outs haven't really worked, and tribunals have said, even if it's carve-out, states still have to pay. So how do we find a middle ground where states maybe do not have to pay for what they are doing, if that is possible at all?
Very interesting question, and there, I think the recourse which the parties have been taken is to the lex marcatoria principle, to say that we'll go by the customary rule, we'll go by the customary law. But I think with the 2018 shift, it's going to be very, very difficult to have these carve-outs, because when Netherlands reformed its new series of the BIT in 2018, it completely incorporated the Paris Agreement. So these kind of carve-outs and this kind of hands-off positions will soon, I think, be cracked down in the enforcement regime. So I think the customary law, although may be pushed in, but I find it very difficult in times to come if the willingness is towards bringing about what you decided at Paris and now the new COPs.
Yeah. So we are absolutely out of time. On behalf of me and Purnima, I thank the entire panel for such a wonderful and engaging discussion. And thank you. Thanks, all of you.
Thanks to the co-chairs as well. Thank you very much.
Okay, just while we're having the photos done, I'm just going to tee up what's happening next. We've got the GAR debate now, the next session, which, as I mentioned, and as you will have seen from the program, is on the subject of artificial intelligence in international arbitration. And will artificial intelligence make arbitrators redundant, and will it make hearings redundant? So we're going to be having that session shortly. Danny, thank you. So heed my call and come in. Thank you. Yeah, sure. Okay, just before I invite the judges and to come onto the stage, just one last call. Can those of you who are about to come into the auditorium please come in and take your seats? Thank you. Okay, I'd like to invite the judges to come in, please. Thank you. And then I'll introduce the judges, and I'll also introduce the speakers, and then having lit the touch paper, I will then stand away and let them work their magic. So can I invite the speakers to please, the judges to please come in. Hey, Niti, good nice one. I'll turn this off, actually. Okay, before I introduce you all to the judges and to the speakers, I'm going to make one last call to those of you who popped out briefly for a tea or a coffee. Please come back in. We're about to begin, so I would ask you to please come in. But in the meantime, I'm going to introduce the session, the last session of the day, the showpiece debate, which is always a great way for us to end GAR events, and this year is no different. We've chosen a very controversial topic, as we always do, and very briefly, it's on the subject of artificial intelligence in international arbitration, something that has been getting a lot of airtime, quite rightly. Innovation never ends, and no one knows where the beginning is or where the end is. So that's what this debate is intended to tease out. We have got two speakers for and against the motion, who I'll introduce shortly. And we have a panel of 5 judges who you see sitting there in the row of 5. We have Justice Karnik of the Bombay High Court, a sitting judge of the Bombay High Court, who's kindly agreed to chair this august tribunal that we have in front of us here. On his left, we have Sapna Jagtiani, KC of the Attorney General's Chambers in Singapore. And on her left, we have Arun Chawla, who is the director of the Indian Council of Arbitration. Working to Justice Karnik's right, we have the wonderful Niti Sachdeva of MCIA. And last and certainly not least, we have Kevin Nash, the registrar of SIAC. So thank you all judges for agreeing to oversee these proceedings, which will no doubt be good-natured and stimulating, and we look forward to it. I'm going to briefly introduce the 4 speakers, and then I'm going to step back and I'm going to let the proceedings begin. So, as you can see from the screen, we have, for the motion, we have Padmaja Kaul, who is a partner at Indus Law here in Delhi. And to her left, we have Rishabh Gupta, who is an advocate in Bombay and also a barrister at 20 Essex Chambers. And then, as you can see from the screen, against the motion, we have 2 equally fabulous speakers. We have Ankit Kushu, who is a partner at Kachwaha & Partners here in Delhi. And also from Delhi, we have Gautam Mishra of CAM. So we look forward to a great debate. What's going to happen, and the last thing I'm going to say is, the advocates have a time limit. So we're going to hear from one of the advocates for the motion, then one of the advocates against the motion, then the second advocate for the motion, and the second advocate against the motion. And then the panel of judges are going to work their magic, and they're going to ask their questions, and they're going to delve deep into the submissions. And then there will be an opportunity for the advocates to make some very brief closing submissions. And there will be an opportunity for the audience to ask some questions. As always, we encourage questions. There's no monopoly on wisdom, so please ask questions. And we look forward to that. And then there will be, at the end, a show of hands and also a vote of the judges as to what they think the right answer is. So on that footing, having lit the touch paper, I'm going to step away and hand over to you. Thank you.
Gautam, shall I keep time? Oh, for the 5 minutes, yeah. Okay, people will keep an eye.
Namaskar and a very good evening, honorable chairpersons, esteemed members of the jury, my fellow panelists, ladies and gentlemen of the House. I rise before you today as the first speaker in support of the motion and have the onerous task of asserting that AI will lead to fewer arbitration hearings and a reduced need for arbitrators, which essentially threatens the future of your employment as well as mine. So now from driverless cars to critical surgeries, from Amazon to Netflix, AI plays a crucial part of our daily lives. So it is naive to assume that arbitration will be immune to this. But first, let's understand what is AI. Have you ever wondered when you listen to music on Spotify, how every song recommendation feels like it was handpicked just for you? The answer lies in the innovative use of AI and the layers of machine learning and deep learning in it. Spotify, through machine learning, analyzes your listening habits, the genres you enjoy, the artists you follow, and the times you skip, repeat, or like a song. And by studying these patterns, it creates a personalized music profile just for you. But the magic doesn't stop there. Spotify's AI goes one step further. It begins to understand the very essence of music itself. This is where deep learning comes into play, where artificial neural networks, like the neurons in our brains, analyze the tempo, the pitch, the rhythm of each song, creating a rich tapestry of musical understanding. Spotify's AI constantly learns and evolves and adapts to your changing needs and changing tastes. So the next time you press play on Spotify and feel like the music was chosen just for you, do remember the dance of machine learning and deep learning behind it. Now let me dive back into the motion. As we all know, arbitration is often preferred for its party autonomy, flexibility, and confidentiality. But it is not to say that it doesn't have its own drawbacks. The process can be lengthy, could be expensive, and subject to human error and bias. This is where the precision of AI comes in handy. As most of us have experienced, arbitrations can feel sometimes like drowning in a sea of paperwork, enough to even make the most seasoned arbitrator's head spin. But why fear when AI is here? AI platforms like Relativity are already being used to come up with more targeted and focused arguments through the swift review of documents, identifying key issues, and filtration of the relevant data, thus potentially reducing the number and length of hearings. Scheduling hearings can also be a tough one, with arbitrators' schedule being as packed as a Mumbai local train during rush hour. Enter AI to tame the chaos. There are platforms that sort calendars and create schedules, thus optimizing time. Moving forward, in our bustling legal jungle, where every lawyer is vying for the juiciest cases and trying to achieve their annual targets, suggesting arbitration might just be the norm. It's like a game of legal musical chairs out there. If you don't act fast, someone else will step in quicker than you can say objection. But predictive analysis using AI is the future. In fact, we are already witnessing the advent of AI platforms like Lex Machina, which can act like crystal balls for cases, objectively providing probable outcomes, effectively letting parties decide whether or not to arbitrate. And if all this doesn't make life easier, AI can step in even before arbitration proceedings commence. eBay, for instance, had pioneered online mediation in the 90s. Today, most e-commerce platforms use AI to effectively resolve disputes and grievances, thus eliminating the very need to arbitrate. Star Trek in the 1960s showcased video calling, a concept that was alien to us back then, but we're all using now in our daily lives and very familiar with. Similarly, the integration of AI in arbitration is inevitable. It's not a question of if, but when. To summarize, I would like to quote one of my colleagues, Gautam Mirza, from the other side of the house, from a recent interview of his. Artificial intelligence is the future. And in fact, I and the motion agree with him. So adapt or get left behind. Thank you.
At the thought that the speaker for the motion would rather appeal to an AI to adjudicate the motion for today. Good evening, members of the panel. You're truly in the best position to evaluate whether an AI can do your task today, let alone do it better. Before I present my arguments against the motion, some incorrect presumptions need to go. Any argument that AI will mean efficient arbitrations is discounting efficient arbitrators. Any presumption that AI can crunch data and produce results, like my co-panelist said, is discounting that the arbitrator can use the technology, use the assistance of the technology to become even more efficient. Any argument which says that technology will not be prejudiced is premised on an incorrect understanding of the technology. When it is said that AI will be neutral because it doesn't carry the prejudices of a human, what it really means is that AI will be mechanical, and that would taint the arbitral award as being perverse for non-application of mind. All the best to those in favor of the motion to undo this time-tested jurisprudence. The speakers for the motion have an extremely high burden to make a case. I have some fundamental points to make as to why AI does not mean less arbitrators or less arbitration hearings. First, non-application of mind. The basis of any arbitral award is not mere crunching of pleadings, documentary evidence, witness statements, legal precedents. An arbitral tribunal is required to apply its mind to factors such as practicality, executability, discretion, equity, applicability to the law. And to process these factors, the data set should include the experience, the learnings, and wisdom of an arbitrator on so many things: human behavior, on the ground knowledge, specific industry experience, social and emotional ability to judge witnesses, ability to analyze technical arguments and its applicability. Does any AI today have this data set? No. And given the critical issues around privacy regarding data of such human experiences, can this data ever be compiled ethically and legally? No. Critical for any arbitration is appointment of a suitable human arbitrator who possesses both the qualification and experience. How do we create AI arbitrators of this kind? By cloning and mapping them? Therefore, even in the fantasy world where technology is best advanced, it still depends on the big data. And that big data is neither available nor is there a legal or ethical way to create such data. Second, neutrality. Assuming through some unimaginable technology advancement and through some unimaginable unlawful regime, this big data of the kind which can map and clone an entire arbitrator gets collected. how will parties select a neutral arbitrator? For an AI in real life will be nothing more than an algorithm and a code. Who would own these algorithms? Will there be some laws regulating these codes, the applicability of such technology? Can parties be given access to these proprietary algorithms? These are questions of neutrality. And what do we understand? What will we understand by this concept of neutrality in future? Will it be a private software or a government software? Which governments? Which governments will regulate it? I ask you, will China rely on a private American software as a neutral AI arbitrator or vice versa? Today, which companies are even assuring us that their AI will be free from such challenges of choice and neutrality? And tomorrow, when AI companies do that, how workable is it going to navigate such challenges? All to replace a human? The next fundamental issue is of transparency. Generative AI is often described as a black box, and rightly so, on account of lack of visibility over its inputs and operations. The parties will never know the reasons behind the decisions, resulting in reduced transparency and trust in the process. This will raise due process concerns and eventually roadblocks in enforcement. This is going to be an appellate lawyer's dream. Imagine the sudden spurt of challenges on the ground that the award suffers from lack of reasoning. We have been examining the issue of reforms in arbitration in platforms like the GAR Live for many years now. We are constantly grappling to make arbitration process more trustworthy, and arbitrators and arbitration hearings are the core of it. Today, in 2024, the ability of AI to reduce arbitrators and arbitration hearings is more in the realm of future fantasy rather than necessary priority to expend the energy of practitioners and arbitrators. The first speaker for the other side made a very interesting point of using Spotify. But I think it was very naive of her to compare justice delivery system to that of listening to music. Frankly, the cost-benefit analysis on time and cost to replace humans by AI does not sound a high priority item for the fraternity today. I would like to conclude by saying, I have always been convinced, like my co-panelist, Gohar Mirza, that technology will ease the work of dispute resolution for already efficient arbitrators. And yes, AI is the future, but cannot replace humans today or any time in the foreseeable future. In the end, I would like to leave you all with just one thought. Any attempted justice by AI is like Solomon's justice without heart and mind. Thank you.
In the 5 minutes that I have, I just want to make 5 points. First point, let's all be very clear. The motion for today's debate has nothing whatsoever to do with replacement of arbitrators. It has nothing whatsoever to do with replacement of arbitration counsel or arbitration hearings. My burden is much lower than that. I'll come to that shortly. They haven't even engaged with the motion. Had the word replacement or substitution in fact appeared in the motion, I wouldn't be standing here and defending it. Because I believe, and my co-debater believes, very genuinely, that what we do as arbitration counsels and what we do as arbitrators is a uniquely human exercise. The art of persuading someone through written and oral advocacy is a pure human endeavor, and I hope it stays like that. That brings me to point number 2. What precisely is our motion? Now, you never heard them even mention the motion because they don't want to engage with the motion at all. I'll read it out for you. The motion is, this House believes that AI will mean less arbitration hearings, focus on that, less arbitration hearings, and less need for arbitrators, less need for arbitrators. Now, I'll engage with both of those things. We all know or don't know what AI means. I'm not going to spend time on that. So second point, less arbitration hearings. No one is saying that AI would replace arbitrations or would replace the need for arbitration hearings altogether. What this motion requires us to show is that ultimately the amount of time that we would spend in the hearing room, the number of hearing days that we would have would go down because of the use of AI. Now, I don't think we can genuinely debate that point. Those of us who do domestic arbitrations in India know very well that we spend an insane amount of time, for example, in recording evidence through use of stenographers. 10 days are very often spent on a couple of witnesses just recording their evidence. Now, if that gets replaced by an AI-assisted live transcriber, of course that comes down. We spend far fewer days in the arbitration room, and therefore the hearing days come down, and therefore the arbitrations become actually faster and less costly. Another very typical example of this would be admission denial of documents. That doesn't need human intervention, really. It can all be done through AI, and therefore the number of hearing days spent go down. Now, that's on the second point. That brings me to my third. Less need for arbitrators. Again, there is no reference in the motion whatsoever to arbitrators being replaced. The question is that would there be lesser need for arbitrators because of use of AI or technology? Now, there is a world in which I understand arbitrators get replaced altogether by AI. Apparently, eBay has some very high volume, low cost, commoditized arbitrations where there's no human intervention at all. But frankly, none of us would ever do those kinds of arbitrations. We do complex commercial investor state arbitrations. And there, I believe, never ever would there be a situation where the arbitrators would get replaced altogether. But what would happen with the use of AI is that the tasks which the arbitrators perform today would change so that many of the tasks which today are being performed by arbitrators and are very labor intensive would perhaps be taken up by AI. That could include, for example, writing terms of reference. That could include giving out procedural orders and so on and so forth. Now, that's precisely what this motion is about. Remember, it's not about replacement of arbitrators. It's just lesser need for arbitrators. And lesser need for arbitrators doesn't mean replacing arbitrators. It simply means you don't need an arbitrator for each and every task that he or she currently performs in an arbitration. That's all my burden is. That's all her burden is. It's not anything more than that. And as I said, we are not arguing for replacement either of arbitrators or arbitration hearings or arbitration councils here. That's point number 3. Point number 4. Now, you heard a little bit from Ankit about how there are all these problems with AI, hallucinations, inaccuracies, ethics, confidentiality, and so on and so forth. The reality is all of that is irrelevant to this motion because those concerns come in only if you're using AI solely by itself. We are not even advocating for that. We are not in that eBay world at all. We are talking about AI assisting the arbitrators and the arbitration councils in their arbitration such that the number of arbitration hearing days go down and the need for arbitrators across the entire spectrum of tasks goes down. So none of those concerns, and you'll keep hearing those concerns perhaps from the second debate as well, none of them are actually relevant on the motion at all. And that brings me to my last and final point, which is more a value proposition point. You know, as I was preparing for this, I was just thinking through my own trajectory as a lawyer. 15 years ago, I was a first-year associate in a law firm in New York, in some basement, perhaps reviewing documents, spending a lot of time second-sharing witness interviews. And I hated everything I did. I used to tell my friends 90% of what I did is just really boring, mind-numbing, soul-sapping work. Today, 15 years later, I think it's the opposite. 90% of what I do, I really enjoy. I find it challenging, and 10% is administrative and boring. But that's not because the tasks which I didn't enjoy have disappeared. It's just that I'm surrounded by more people who are able to assist me in doing that work. But why should it be that the next generation is subjected to the same torture that some of us have been subjected to? Why should they have to go through the same trajectory? Ultimately, the use of AI would mean that all of us would be doing things which are far better, far more suited for our skill set, and far less labor intensive than some of the tasks we perform today. So, ladies and gentlemen, I urge you, be kind to the next generation and vote for the motion. Thank you.
Well, thank you, Rishabh. I think it was a great speech by you. But fundamentally, I will again read the motion, what it exactly says. The motion says AI will mean less arbitration hearings and less need for arbitrators. So the former point, of course, my learned friend says, and I should say they agree with us, on the point that it will increase efficiency. We all are advocates for efficiency, and definitely AI will increase efficiency in the process of arbitration. But less need for arbitrators. I'll pause there for a moment. I actually took out an image that I want to show to everyone. So everyone realizes what an award will be. So an artificial intelligence system was asked to make a picture of Mother Teresa fighting against poverty. And this is what the result was. All right. The reason for showing this is the need for human intervention or the need for human judgment is paramount when the process is of adjudication. Now, when in 1956, John McCarthy coined the term artificial intelligence, he actually drafted a definition which I would like to read because there is a little bit of confusion on the other side about what AI exactly means. Let me read that definition for all of you. Making machine behave in ways that would be called intelligent if humans were so behaving. The fundamental question or the fundamental coining of the term artificial intelligence has embedded itself with comparing itself to human intervention. So therefore, nobody here, I'm sure Rishabh also doesn't say that human intervention is not required. I'm sure that's the point. So that is why I say Rishabh is with us and Padmaja is alone. But that's not the point. Let's move forward. What is AI and what is the principal fundamental proposition of AI? Streamlining administrative actions so that, I quote Lucas Bento and his book on international arbitration and AI called Time to Tango, where it says that administrative tasks can be given to AI, but let the arbitrators arbitrate. Now, that brings me to another point. Padmaja Kaul mentioned about driverless cars. I want to give an example of EVs. We recently see in the automobile sector, there is a boom on electric vehicles. We always had fuel-driven vehicles and they were always doing very well for us. But then when EVs came in, we were all a bit skeptical about the acceptance. Today, if you see the efficiency that EV offers, is the prime factor that everybody is accepting those cars, and the number and the market of EV is increasing manifold every year. Which means that if efficiency is increasing in arbitration, the number of arbitration proceedings will increase, the number of arbitrators will increase, and the demand for more and more arbitration will increase. Because if 1 year time is reduced to 3 months, more and more parties, more and more disputes want to be referred to arbitration. So I am against that motion of saying that there will be less need of arbitrators. Rather, by bringing in AI, we need more arbitrators. We will need more arbitration hearings because nobody is going to replace a cross-examination or a hearing. So therefore, I am against the motion, and I would like to close my submission on that point, that AI would mean more arbitration, and this motion has nothing to do with coming into human intervention. So thank you. Thank you very much.
Thank you very much, speakers. I have one question on behalf of the judges. I take the liberty of speaking on behalf of all my fellow judges. And it's a question for those against the motion. And the underlying premise of the arguments on behalf of the team opposing the motion is that all arbitrators are currently human. Now, some of us have our doubts on that based on personal experience. Do you have any evidence for this?
Yeah, I'll take that, Sapna. I think the question, the way you've crafted your question is that what is the proof of showing that whatever awards we are getting are actually being done by the arbitrators themselves? So that is, of course, as practitioners, that's a belief that we all have. Sorry.
It was more light-hearted than that.
I know. No, but I am a serious person and I'm a serious lawyer, and I would want to address that. So the system of arbitration or any other dispute resolution or judicial process is run on belief. The belief that yes, a person sat and did it. Of course, we all know what's happening on the ground and how it is happening. And as I said, we are not against the point that AI or any other tool or any other person, for that matter, is being used to write an award. But the system of belief has to be followed in a manner that we always believe in the system that yes, the award has been drafted by the arbitrator himself or herself, whosoever is on the tribunal. Yeah. You switch it on. Take out your mic. But to answer your question, there is no way to find out. Yeah.
Just to add to what Gautam said, if there's a situation like that, so we need to replace the inefficient arbitrators by efficient arbitrators and not replace the humans by machine. So.
This one is for you, Padmaja. Well, the motion is quite scary. I shudder to think if the word arbitrator is replaced by the word judges. Now, Padmaja, you said you compared Spotify with the legal processes, and this certainly was not music to the ears of your opponent Ankita. Now, we got the impression that you are speaking about replacing the arbitrators with the AI. Your colleague probably changed the narrative after the. So, what was your what is your take on this?
So, if I may. Yeah. Thank you, Justice Karnik. So, not at any point during my arguments did I try to say that there's going to be a replacement of arbitrators. The motion says reduction of arbitration hearings, which is where I gave examples of various AI platforms that are being currently used to sort of structure arguments so that the lengthy hearings can be given a go-by. So that's one aspect of reducing the number of arbitration hearings. When it comes to reduction in the number of arbitrators, I think the efficiency increases. And as my colleague tried to say, that what we are trying to do is that with the advent of AI, and it's at an embryonic stage. I'm not saying it's happening now or it will happen, just tomorrow. It's the future. We're looking at that, looking at it from that point of view. And the reduction of need in arbitrators is something that I tried to say while I spoke about e-commerce platforms. I'll give you examples which are happening currently in Mexico. There are pension claims which are being absolutely decided by AI adjudication. So thereby eliminating the need to arbitrate itself. For that matter, when I spoke about predictive analysis, which tells us objectively whether or not to arbitrate, thereby giving a go-by to the arbitration process itself, then limiting the need for arbitrators. The third, there's China, who's also using smart courts, and I'm reading a few articles now that I was given the task of reading about AI. But China has been using smart courts since 2019 in certain IP and financial typical loan default issues. So it's not new to all of us. It's just happening around the world and it's gaining recognition. But as my partner, and I wanted to address that aspect, what he tried to say was we do complex commercial arbitrations. Not 1 minute did I say. I was trying to give the analogy in what situations and in what kinds of disputes can we use AI adjudication.
On a more lighter note, and in her defense, this is what happens when you get two busy lawyers to debate, right? They don't sit together, prepare together. You have to live with that. Yeah.
No, actually, Rishabh sat with me before the session.
That's why we were more coordinated than here. Yeah. Yeah.
I always felt the task of judging was a very difficult one, and having heard the cogent arguments of both the sides, I am now firmly of the belief it's very difficult. But one question that definitely comes to my mind is that both the sides have not discounted the role of AI. So, but are there any limitations or types of disputes where artificial intelligence is not effective in comparison to human arbitrators?
Not effective. Yeah. No, I firmly believe, and I hope I was clear on that I don't think human element is going out of this, because what we love about what we do, and which I think is very important, is the act of persuasion, right? Through our written advocacy, through our oral advocacy, and that's a purely human exercise. Now, that may not be that important in those cases where the element of human intervention actually is more costly than the value in dispute. And those eBay, commoditized, large volume, low cost arbitrations are a great example. If you're fighting over a couple of $1,000s, why would you involve humans in that? Because they'll cost more. But what we do, or at least what all of us want to do, I can't see how human intervention goes away altogether. What AI does, I suspect, not that we're using it a lot today, is that it allows us to focus on those aspects of human intervention where we are genuinely bringing in value. And therefore, I think that in those complex, high-stake, bet-the-farm commercial disputes, investor-state disputes, I don't think AI will solely replace anyone.
If I may just address your point, so what you were trying to ask is what kind of disputes AI will not be effective, right? So let us forget arbitration. We are all sitting here in a fancy setup. Let us go to a family court in a remote area in Maharashtra. Let's assume that. Can AI be put into a family dispute? Answer is no. Can AI be put in a criminal dispute or a criminal matter? Answer is no. So it is just that AI, because it's a fanciful way of putting it, that you place your statement of claims, statement of defense, your documentation into a system, give it a prompt, and get an award. Is that the only thing? Your question actually is very important for a larger cause or for a larger picture that we have to see. And again, as Rishabh agrees with us, that AI is only a tool for efficiency. It is only reducing human intervention when it has to take administrative tasks. And he agrees with that, which means that when an award is to be drawn on a prompt created on an AI system, it still has to go to an arbitrator. Arbitrator will have to still see it. And an example given by Ankit earlier, that a dispute between a Chinese company and a US company, whose algorithm is going to be used, because AI is absolutely based on algorithm. Nobody disputes that. It will only pick up something available on the internet or something which has been fed into it, take its own predictive coding or generative way of finding out the resolution to that problem. But still, somebody will have to sit and understand and come to a conclusion. So that, I think, was the...
There seems to be a consensus that there are certain disputes where AI is not effective at all. Is that right?
Effective, I will say yes. Efficiency increases, but lesser need for arbitrators, the motion exactly, we are against that. It will never, as I said in my chance, that it will actually increase arbitrators, because more and more attraction will be created in terms of resolution of disputes. So I think it will increase arbitrators rather than decreasing arbitrators.
May I just add one more point? I think I would like to clarify. In fact, in Netherlands now, in family disputes, there is prior AI mediation so that the disputes don't go to court.
As I said, Padmaja.
Data sitting there, actually, in fact, trying to mitigate the need to go to court.
And thank you once again for supporting me on that cause. I was referring to a remote village in Maharashtra where these algorithms will not work. So of course, Netherlands, a country which may be more advanced in their systems, maybe that is applicable. But we're talking about a rural area where this will not work. So just an example over there.
Well, I leave it to how you would want to discuss either sides. We heard about predictive analysis, and I always wonder that whenever we talk about technology, the thought which comes to mind is garbage in, garbage out. We have Supreme Court, High Court judgments, which we've seen, arbitration awards as well, which are actually, different opinions given by different arbitrators. So are we trying to say here that we'll have sort of data which has gone into, and if it is, let's assume you have one set of data which has interpreted the facts in a particular way and has given a judgment, and you don't have the data on the other side, then how reliable is the predictive analysis really?
Suspect not. It isn't, and which is why no one, at least on this side, and I fail to understand why there's this sense that there's agreement on that side as well. But in any way, no one on this side is saying, therefore, just let judgments be or awards be written by whatever predictive analysis it might be. I don't think that's right. I don't think it's going to happen. But that's not what the motion is. The motion is less arbitration hearings, which doesn't mean replacement of arbitrations. It simply means fewer days spent in the hearing room. And it says lesser need for arbitrators. It doesn't say less arbitrators. Had it said less arbitrators, perhaps your question, in the context of this motion, of course we can engage in an academic debate about that, but that's not what the purpose here is. Within the four corners of this motion, the fact that predictive analysis may not lead to a fully reliable arbitration award, and therefore there's a need for arbitrators to stay involved, is neither here nor there. We agree with that. But I don't think you would also disagree, and I hope no one in the audience would disagree, that there'll be lots and lots of tasks prior to writing of the award, which the arbitrator doesn't need to do. And that's exactly what the motion is about. The motion is not about replacement at all.
Maybe I'll just build off that question. Are you saying is your position that there's less work for an arbitration, or are you reading need as work?
I am reading need as effectively a spectrum of tasks that any arbitrator performs in the context of a single arbitration. And you don't need arbitrators for many of those tasks going forward. However, to Neeti's point, there will be certain tasks, such as, for example, writing the arbitration award, where you wouldn't need the arbitrator.
Maybe if I could ask those opposing the motion, of course, Mr. Gupta has skillfully went after the framing of the motion. So to those opposing, what is the moving parties voting, and what do they have to show? So if there is one more arbitration hearing, if there's one more arbitrator appointed, does the motion then, or those moving the motion, fail? So what is your view of the moving parties' burden, and what do they have to show?
Can you repeat the question, Kevin? Sorry.
So,
just pausing there for a second. No, you're audible. But just pay attention now, because there is absolutely no engagement with the motion at all. The question from Kevin was, what exactly is your interpretation of the motion, and whether we have met our burden?
Okay, maybe we should make sure that I'm asking the question.
Yeah.
When I talk about skill and accuracy,
No, I'll tell you. Kevin,
I've seen this act in many rooms around the world, and it's always about.
Yeah, please, Kevin.
So
Kevin, please repeat. Yeah.
The question that I was asking is, you discussed their burden. So what is it that they have to show? If there's one more arbitration, if there's one more arbitration hearing, do they then fail? What is their burden, and what do they have to prove?
The burden that they have to prove is, firstly, first is not to confuse the motion. That is the first thing that they have to do. Second is reading exactly what is written. I will read it again, Kevin, because I think there's some amount of confusion again that Rishabh is trying to create. AI will mean less arbitration hearings and less need for arbitrators, full stop. What Rishabh is saying is less need for arbitrators to do more work, more administrative work is what he's trying to give the impression. That is an incorrect impression, because the first part actually takes care of it. Less arbitration hearings, which means administrative tasks taken care of, and less need for arbitrators, which means if the arbitration hearings are reducing, we need lesser arbitrators. That's exactly what the motion is. So by confusing the motion, you will not take your cause forward, is what our response would be.
I think we're inviting questions from the audience now, and I think there should be microphones around. Yes, sir. Yes, absolutely.
Wow.
I don't identify myself either with the proposition or against that. I have been a judge, I have been an arbitrator. God knows how many years, I don't even count them. Now the point is, there are certain areas where the human emotions play. AI will have no scope whatever. I was just pointing out to Gautam, and he rightly pointed out, Gavar pointed out, a family matter, a criminal trial. Whatever you may do, whatever your predictive analysis, we can't afford to have AI enter into that any more than AI will start a war against Pakistan or China or anything like that. The point is, if the idea is to make AI a powerful tool so that the arbitrator's task is lessened and he is able to concentrate more on arbitration than the peripheral issues, efficiency of arbitrators increases. If the efficiency of arbitrators increases, they can dispose of more number of matters. The difficulty will be then the judges will become redundant. You and I, Brother Karnik, would be out of office if the AI were to take over all these things. Judges are, because today the judges are overburdened. I know you are working in Bombay High Court, I worked in Bombay High Court, Kerala High Court, and in the Supreme Court. Our backs have really bent because of that. Now, if arbitrators were to take away more than 50% of my case, why do you need so many judges? Then more number of judges will not be there. The number of judges will need. Yeah, in fact, the motion should have been worded like that, according to me. Anyway, on the way the motion is worded, well, it's a powerful tool, but it can't replace the human agency.
Thank you.
That seems to be the balanced view of taking it.
Thank you very much, sir.
Yes. If I can be naughty, I'm going to just ask something slightly different tack. Since we've got three, and look, every debate that GAR does has to have some controversy in it. It's all good-natured, right? It's all good-natured. We're all good friends here, right? Now, we've got three people on this judging panel from institutions, okay? Now, let's leave to one side the conduct of the arbitrations. Let's think about the administration of the arbitrations. What I often wonder what role AI could have in the administration, not to do any of you out of a job, but what role could it have in the administration of arbitration, all the stuff that preludes arbitration? And also, I've often thought to myself, and yesterday we were discussing very important topics about better gender equality and diversity in arbitration, and the wonderful role that institutions play in ensuring women are properly represented. AI couldn't replicate that. Surely it couldn't. It couldn't do it as well as human beings could. So, those are just a couple of thoughts I have on the administration of arbitrations.
So Gautam, can I just add, the previous session where Sadaf Habib was talking about inclusion, she also spoke about humanness in the process, which I stand for today. The humanness in the process cannot be taken away. So I think that's the theme everybody is following, and thank you, Justice Srikrishna, for accepting that on behalf of the panel.
Thank you so much. It's been a really interesting session, and I thank the organizers for organizing this session. Just first, my question would be, of course, I hope to hear the judges' final decision on the motions, whether they are for or against. But I think more than that, I wanted to highlight, the point that there's two perceptions throughout the debates. One is coming from the arbitrators, so those of us who act as arbitrators. I think their concerns are more from the perspective that we don't want to lose more work, right? And the other perspective is from the users. I think that's something that's more of concern, that if, most of the work is kind of delegated to AI, even if it's administrative, there's a little bit of shift. Basically, the question comes that who will be accountable in cases. So I think accountability the focus should be on, how to pin accountability if we involve more and more AI, rather than worrying about, the replacement of AI, arbitrators. So yeah, that's about it. But I hope to hear the viewpoint of the judges.
Justice Chauhan,
I wonder whether it is not our human hubris to believe that we are non-replaceable. And I was just wondering to myself, when Ford invented its car, were the horses saying that they are non-replaceable? Because I like to believe that if you look at two factors of AI, number one, that AI can also incorporate the social biases that we have. That is one of the criticism of the use of AI, that the metadata is beginning to reflect our social biases. Now, if it can reflect our social biases, what would prevent it from reflecting human emotions? Number one. Number two, look at the broader picture, not of today, not of 2024, year 3024, 100 years from now. AI would be replicating itself. In fact, if you remember, when the Deep Blue was playing the chess against the master, the world champion, it began communicating with another machine. They had to immediately turn it off. We could not even understand what was the communication between that computer and another computer. Now think of a century ahead. Perhaps they will start generating their own robots, which have nothing to do with us. In fact, now there are robots who are saying, we are a threat to your species. So I think it's part of our human hubris to believe that being the most intelligent species, we are non-replaceable. But think about it, 100 years from now. And therefore, I believe that 100 years from now, all of us will be replaced. That's what they're already talking about. By 2070, most of the human beings are going to lose their jobs to AI.
If I could just add one thing, we never put the burden so high, but Justice Chauhan has put it very high and yet met it. So if that can convince you, I hope what was said here can convince you for sure, because that's not really the motion. That's putting it very high. But of course, he's made a very compelling argument even in favor of that motion. Hi.
If I can answer Justice Chauhan, the motion today is the House believes that AI will mean less arbitration hearings and less need of arbitrators. This is as of today. And what we're talking about is a hypothetical discussion after 100 years. We don't know what will happen after 100 years. Whether AI will, where will AI be? Will it be a technology which will die down on its own, or will it survive? And as regards human element, they say that knowledge comes and wisdom lingers. So if AI is asked to render awards, there's so many great arbitrators here. Justice Srikrishna is here. I cannot imagine in my lifetime or any AI being able to replicate his wisdom and trying to render an award. Impossible. I cannot foresee a future like that.
Just to clarify, the motion says AI will mean. It doesn't say is doing it today. It is will mean less arbitration.
So that's what I said. AI, it's today or in the foreseeable future. We cannot sit here debate on what will happen 50 years down the line. We don't know where we are, where you are, and what technological advancement has happened. So the motion is the motion is today or in the foreseeable future.
But it's right here. I think I proved it with the number of examples of platforms that GAR himself is using.
And on the lighter side, Justice Chauhan gave an example of horses being replaced by Ford cars. But sir, if you see when there are derby races and car races, so the horse racing is still a thing and it cannot be ever replaced. The fun, the entertainment factor that comes out of a horse racing will never be replaced by a F1 car. So just on a lighter note, on your comparison of horses versus cars. So I'm saying Justice Srikrishna cannot be replaced. Maybe there is a better Justice Srikrishna 2.0, but he can never be replaced. So that's the point.
Thank you very much for the debaters. I think we all agree.
Of Justice Srikrishna.
Just one question. Hi.
Sorry, we can take the questions. I think the judges would like to deliberate a bit much, but before... Yes, please.
Yes, Ford's invention helped us in replacing horses with cars. We still need stud farms and horses. Have we replaced them all? Our cars are going to produce their cars and their cars and their cars.
Absolutely, sir.
No, horse will continue, the cars will continue for different purposes. So perhaps that is what the AI solution will be.
Thank you very much, Justice Srikrishna. Okay, let's hear the last question then.
Hi. So my question really is efficiency, but at what cost? And just to expand on that a little bit, we are all replaceable. It's only a matter of when. So data is the lifeblood of AI. AI will take in data, and then we have concerns of confidentiality, especially in our commercial arbitration. We have concerns of data protection where personal data is involved. We do not know what data is processed how. There is concerns of inaccuracy because the more data you feed in, AI tends to generalize. And then there are concerns of human biases that you would naturally tend to agree with the results of AI more than you would of, say, another human being. And that is a very normal human bias that goes into place. The data-related biases are something which are, in addition, coming into picture. So amidst all of these concerns, do we really think that we should promote use of AI? Maybe in procedural aspects, we may be able to use it at some instances in arbitration. But when we are talking about the substantive aspects, should we really support the use of AI in something as crucial to justice, or maybe not justice delivery, but certainly for commercial justice as arbitration? So efficiency at what cost?
Thank you very much. I think we can conclude. Let's do it with a raise of hands. All for the for the motion. If you could just raise your hands, please. We have about. Yes.
Not very precise. Just about 21, I think.
And for the against the motion. We clearly have a majority in there, yes. Sapna, would you want to?
Well, the court of public opinion and the court on this stage are very much in agreement. We find in favour by a full consensus for those against the motion. And the main reason for that is we don't agree with the way that those for the motion have sought to reframe it in a way that we think doesn't do justice to the motion. So those against the motion win this debate, but we're very grateful for the excellent advocacy on both sides, very passionately argued, and thank you so much for the audience participation as well. Judge, I don't know if you want to say any closing remarks to close the debate.
Well, thank you all for being very patient. And I'd only say this, that I completely agree with His Lordship Justice Srikrishna, that both the sides tried to make out a balanced argument. I thought the other side should have gone against the motion and taken it head on. They tried to balance it, but AI is here to stay. Our take on it is, the arbitrators can never be replaced. What AI will be doing is only collecting the data, analyzing the data, but the decision has to be always of the human beings. There has to be emotion involved. There has to be a good thinking involved. There has to be application of mind. AI can be used only in respect of some domains. So AI is just a tool in our hands, and we have to use it as a tool, keep it at some distance, and that is how we have to train ourselves. Because the point that the other side made out is there may be increased need for arbitrators. The reason being this: the more data we have to really sift the grain from the chaff. And that is easy. But sifting, after the AI is there, when you have so much material with you, so much analysis, so much reasoning with you, but thereafter, if you have to sift the finer grain from the shaft, we need a very creative mind, and that can be only human intellect which can do it. That is my take on this. That is our take on this. Thank you so much.
Ladies and gentlemen, we have been running a little bit late, but sounding great, as they say in radio, I believe. So well done, everyone who's been on the stage today. And wow, now I look back, I can see how many people are still in the room, so that's incredibly impressive too. It's my job to bring us to a brisk conclusion because we have drinks waiting for you at a different location. If you don't know where that is, it's the Taj Hotel, which I will assume needs no further explanation, but Gautam will give that if required. The drinks are on the poolside lawn, and they are courtesy of the generosity of Saraf and Partners, to whom we are indebted. You will need your Delhi Arbitration Week badge to get in, or your GAR badge, so please remember that. And there is then a further cocktail reception afterwards in the same venue hosted by Brick Court, I think. So two for the price of one. It's very worth you joining us, and I hope you will. I'm going to hand over to Gautam to say a few final things, but just on behalf of GAR, I would like to say a huge thank you to the one kind of sponsor organisation that is not on screen, and that is the Delhi High Court, to whom we owe so much for the use of, I think, the finest GAR Live venue yet. And it's fitting that we probably also had our biggest GAR Live audience ever around about lunchtime, when I think we were well over 300, and we've never done that before. So hip hip hooray for the arbitration community in India. And if you'd said to the 2008 version of me that I would be standing here today, as Jan Paulsen did in those days, and addressing an audience that was far bigger than Jan Paulsen addressed in those days, I would think, no way, and I'd feel rather excited that it might be true. So, Gautam, over to you. And Josh.
A big thank you to all of you who have remained present till the end. They say in the Indian tradition that in all Katha Vachan and Bhagavat Vachan and all that, the desert, the prasad that is given there at the end is the attraction which makes all the people wait. Now, I don't know whether the reception that is going to come from Saraf and company, the one that is holding you back, or the quality of the debate that was being carried out here and the quality of the talks that were there among the various panels, whichever the cause, I am very happy that you have all persisted in bestowing your attention to the proceedings that were going on, including the charming debate that went on. And this debate will continue till AI comes to rule the roost. Thank you very much. And Gautam has a few words of thanks to convey to you. May you continue with this kind of line of thinking. Not necessary that you reach a decision one way or the other. It's all right. It's all in fun and games. But the ability to analyze a complicated issue, the ability to criticize a contrary view is something that every lawyer has to generate for himself, irrespective of AI. Now, we don't have to wait for AI for do all this. In fact, I was just telling Gautam, I would like AI to resolve Saas Bahu disputes in India and the dowry harassment cases in India. The day it happens, I'll change my view. Thank you very much.
Thank you, Justice Srikrishna. I'm conscious that I am the only thing holding everyone back from going to drinks, which, just to mention, are at the Taj Mansingh at the Lawns, so very nearby. I just want to say some really big thank yous. Big thank you to my wonderful co-chair, friend, mentor, teacher, inspiration, Justice Srikrishna. Always such a generous person to work with. The GAR team, David, Katrin, Savannah, Beth, Hemant, and a couple who can't be here today, Luke and Killian, for all their great work and their partnership and teamwork. The great thing about GAR Live India be it in Mumbai, Delhi, and in the 2 years we did it virtually, is it shines a spotlight on India. And that means a lot to me personally. The rivers of Bengal run deep in my veins, and India is a big part of my life personally and professionally. And it's a great joy that since 2019, GAR has been focusing on India, and it's such a big part of the GAR program. So that really warms my heart hugely. I want to extend huge thanks to all our panelists, all our speakers. They've just been magnificent. I mean, the quality has been stratospheric. I'm sure you'll agree, they've all been wonderful. And, I just want to say just two last things. In the course of the last, a few days, and yesterday and today, and those of you who've been here today and have heard me twice say, we are no longer in time zones where International Women's Day is still happening, but women really matter. And one of the ways that I would encourage, men of course must support every one of you, but to all the women here in the room and who have left, please get involved in Indian Women in International Arbitration, IWIA. It's a wonderful thing for women in India doing arbitration who want to do arbitration, and those who have been in heritage who've left these shores and work abroad. It's a really important thing. Please get involved. The last big thank you is to the Delhi High Court and to all the team here who've been absolutely incredible. I've worked so hard. Thank you for your generosity, a wonderful venue, all your hard work to get everything ready, the beautiful flower arrangements. I mean, I've never seen more beautiful flower arrangements at a conference before. So big, big thank you. And now let's enjoy some social time over drinks. Thank you.
Superb. Thank you. Thank you, Kevin. Thank you very much. Thank you so much. It's so nice to see you. Thank you for being here with us. And of course, coming yesterday. Yeah, I also. Thank you so much. Thank you very much. It's been wonderful. Thank you very much. Thank you. Thank you so much. Thank you very much. Thank you very much. Thank you very much. Thank you so much. Thank you, brother. Thank you very much. Like adults, each other? Yes, yes, yes. Well done. I will. Nice part. Their part was easy. I was telling her,